Welcome to the latest Evershed Sutherland Legal Insights podcast.
I am Charlotte Belcher, a Senior Associate in our Inquiries, Inquests and Investigations team. Today's episode of Evershed Sutherland's Through the Inquisitor's Lens podcast is titled, What are the challenges in navigating data in inquiries and inquests? I am joined by Paul Mertens and Shona Love, barristers at Pump Court Chambers. Paul is the head of Pump Court Chambers Inquests and Inquiries team. He has acted as counsel to the inquiry or has represented a core participant in most of the most prominent public inquiries of recent times, including the Iraq inquiry, the independent inquiry into child sexual abuse, the undercover policing inquiry and the Post Office Horizon IT inquiry. He is a member of the Attorney General's London A Panel of Counsel and Panel of Special Advocates and has particular expertise in public inquiries, data protection, freedom of information and national security. Shona is a barrister at Pump Court Chambers with a broad mixed practice, including inquests and inquiries and privacy and data protection law. In addition to her practice in England and Wales, she is also admitted as a barrister in the Republic of Ireland and as an attorney in New York, United States. Before coming to the bar, she worked as a lawyer at the BBC, specialising in media and information law, and prior to that was in-house at the NHS, managing clinical negligence, personal injury claims and inquests. We will discuss the legal basis for inquiries and inquests to request information from participants and the challenges which can arise in the disclosure of information in those processes. We hope you enjoy.
Thank you for joining me today, Shona and Paul, to discuss the question, what are the challenges in navigating data in inquiries and inquests? Now, it's an interesting topic and there's lots to unpack here, but perhaps let's start off with the background. So, what is the legal framework underpinning the use of data in these types of investigations?
Oh, well, thank you very much, Charlotte. It's really nice to have invited us along today. When it comes to public inquiries, the two principal pieces of legislation are the UK General Data Protection Regulation and the Data Protection Act 2018. I think the important thing for everybody to bear in mind is that public inquiries typically involve very substantial quantities of information, and lots of that information will include personal data. And so the framework is really important in setting out what parties are expected to do and what they can expect others to do when handling that data.
In the context of inquests, the key legal framework is as the same as Paul said, the UK GDPR and the Data Protection Act, together with the Coroners and Justice Act 2009 and the Coroners Inquest Rules 2013. Data protection law governs how a coroner and other organisations handle personal data relating to living individuals during the investigation and inquest process. And that will include things like medical records, witness information and other sensitive material. And alongside that, the coronial framework, particularly the Coroners and Justice Act 2009 and the Coroners Inquest Rules 2013, governs the conduct of the investigation and inquest, including when evidence and documents may be disclosed to interested persons.
That's great. Thank you both. So we've alluded to it already, but both the coroners and chairs of an inquiry, they request a lot of information during the course of their investigations. So perhaps we could talk a little about disclosure requests in the two types of investigation we're talking about today.
Yeah, I mean, in an inquiries context, I think the really key thing to understand is that there are two alternative ways in which information can be obtained. One is by what's known as a Rule 9 request, where a material provider is asked to provide information to the inquiry to enable it to investigate the matters set out in the terms of reference. It must be remembered, however, that that is ultimately a request, and a party can refuse to respond to that request. On the other hand, the inquiry also has the power, if it's a statutory inquiry, to issue a notice to produce information, what is known as a Section 21 notice. That is a more powerful request to make and provides the holder of the information with a legal obligation to provide the information that they hold, and that includes the personal data of which they're the data controller, and to disclose it to the inquiry. I think the other thing that is worth just saying, Charlotte, about that is that where a Section 21 notice can be used in a statutory context, a number of inquiries that we have are non-statutory in nature. And that's one of the difficulties that they face, because they don't have the power to compel evidence. And indeed, we've seen a number of examples in the past of inquiries that began their life as a non-statutory inquiry being converted onto the statutory framework, precisely for the reason that they are then able to compel information to be provided. And from a data controller's perspective, it gives that additional level of reassurance that the information must be provided, and there's then a legal basis in order to rely on when disclosing it to the inquiry.
I think that's a really helpful distinction to draw between the two types of inquiry, but of course may well be subject to change with the Public Accountability Bill going through Parliament at the moment. It obviously isn't yet enacted in law, but certainly is something that can change whether the non-statutory inquiries can have powers of compulsion in relation to evidence. So that will be really interesting to see. How about inquests, Shona?
So I think the important thing to start with is looking at the differences between living and deceased in terms of data protection and the duty of confidentiality.
Yes.
So the key distinction between living and deceased individuals is fundamental, really, in data protection law, and particularly in the context of inquests. So under the UK GDPR and Data Protection Act, personal data is defined as any information relating to an identified or identifiable living individual. So once a person has passed away, information about them is no longer personal data for the purposes of data protection law. However, that does not mean information about the deceased falls outside legal protection altogether. It may still be protected by the common law duty of confidentiality. And so what we see, certainly in the medical context, is that duty continues after death, although it's not absolute. And there may also be limited statutory rights of access to a deceased person's health records under the Access to Health Records Act 1990. For example, a personal representative or someone with a claim arising out of the death. But disclosure may still be justified where it is required by law in the public interest, or is necessary for the coroner to carry out their statutory functions in investigating the death. By contrast, data protection law remains fully engaged for the personal data of living individuals involved in an inquest, such as family members, witnesses, and healthcare professionals. Their information remains subject to the UK GDPR and Data Protection Act, including the usual requirements of lawful, fair and transparent processing.
Thank you both. That's all really interesting. And I'm sure some people today will be listening, and they may well have a number of stakeholders to manage who may have concerns about their data being shared with either an inquiry or an inquest, and certainly have those expectations to manage. What would you say in relation to managing those expectations and how that can be balanced appropriately?
I mean, I think the key thing there, Charlotte, is something that applies very generally, which is communication. Employers need to communicate with their staff the sorts of circumstances in which disclosure might have to be given for the purpose of a public inquiry or indeed an inquest. And it shouldn't then come as a surprise to individuals if at a point in time during their career that information might have to be provided. The other aspect of communication that I think is really important is to explain the methods that can be adopted to protect people's personal data where there's a justification for doing so. And inquiries have a fairly well-trodden pathway that can be adopted to examine whether there's justification for revealing information that might otherwise be considered sensitive by those about whom it relates.
I think that's a really important point in that it's a well-trodden path for inquiries, and we've seen over recent times, for example, the use of junior staff members' names coming up in some of the major inquiries, and how the chairs have decided to deal with that. Perhaps we should talk a little about that.
Yeah, I mean, my experience, Charlotte, and it may be yours as well, and some of the listeners, that although in general, the higher up you go in an organization, the greater the level of responsibility there is for the sorts of things that are being examined by an inquiry, that's not a universal thing. And on occasion, certainly I've experienced more junior members having been at the heart of the things that are said to have gone wrong or that require examination by an inquiry. And in those circumstances, you can, I think, understand why there may be a justification for revealing their name, not because they are a junior member, but because of their centrality to the matters under investigation. And so I do think it's important that people understand that depending on their role, rather than necessarily the level of their role within an organisation, it's likely that an inquiry will or may still consider there is a need to put their personal data into the public domain when it's considering its investigations.
I think that's an important point, bearing in mind the need for transparency in proceedings and being able to fulfil the terms of reference. And certainly, as you've alluded to, there may be occasions where relatively junior members of staff undertake roles or tasks, or perhaps make decisions which are relevant to the terms of reference, and therefore should squarely fall within that. Do you have any top tips, Shona, in relation to how organisations can manage the process of disclosure within an inquest, and how to best manage that with coroner's officers and indeed the coroner?
Thanks, Charlotte. Yes, absolutely. I think perhaps it might be important for me to just address the management of responding to requests first before moving on to what tips I would suggest. Certainly in the inquest space, we're looking at, when we're looking at disclosure, we're often looking at a Schedule 5 notice under the Coroners and Justice Act, which, as we know, creates a legal obligation on the recipient to provide the documents, evidence or other material specified. From a data protection perspective, that is important because the UK GDPR allows personal data to be processed where it is necessary to comply with the legal obligation. So in most cases, an organisation or an interested person responding to a valid Schedule 5 notice will be able to rely on Article 6, subsection 1C of the UK GDPR as its lawful basis for disclosure. The Information Commissioner's Office also makes clear that the processing must still be necessary and that organisations should be able to identify the legal obligation they are relying on. If a care provider or hospital, public body or other interested person has concerns about its own data protection duties, the answer is usually not to refuse outright. The better course is to raise any concerns with the coroner and seek clarification, narrowing, redactions or directions on how particularly sensitive material should be handled. Data protection is not usually a complete bar to disclosure in this context, but it does shape how disclosure should be managed. I think it's also worth mentioning that non-compliance with a Schedule 5 notice can lead to sanctions. A coroner may impose a fine of up to £1,000 for failure without reasonable excuse to comply with a Schedule 5 notice. And on sort of the more serious scale, deliberate concealment, alteration, or destruction of relevant material can amount to a criminal offence. And a recent example, it was reported just early last year that a coroner in Nottingham had fined the Ministry of Justice £500 for failing to comply with the Schedule 5 notice in an inquest into the death of 3 men who were in prison at HMP Loudham Grange. And in that case, the coroner reportedly said she could not think of proceedings that required a greater level of candour and due diligence than these, and adding that the Ministry of Justice had been given chance after chance. So really the takeaway is compliance is not optional.
Yes.
And I think that's probably a good segue to move on to the practical tools, and Paul touched on, I think, in the context of inquiries, looking at redaction. So redaction in inquests is essentially about balancing the principle of open justice with privacy and data protection considerations. As we all know, inquests are generally held in public. And as Paul touched on in the same way with inquiries, the starting point is transparency. The investigation and the evidence relied upon should ordinarily be open to the bereaved family, interested persons and the public in certainly inquests. And this reflects the broader principle of open justice, which recognises that public scrutiny is an important safeguard in the administration of justice. At the same time, coronial investigations frequently involve sensitive material, as we've touched on, including medical, mental health, and safeguarding records, as well as personal data relating to third parties. And so redaction is a practical tool to remove information that's irrelevant or disproportionate to the investigation. And those key principles are relevance, necessity, and proportionality. And the coroner's investigation focuses, as we know, on the statutory questions. So who the deceased was, how, when, and where they came by their death. So information falling outside the scope of that may appropriately be redacted. And as you've touched on, certainly in inquests, in practice, disclosure is often managed in stages. So organisations usually provide documents to the coroner and may propose redactions such as third-party identifiers or unrelated personal information. And then the coroner will then decide what material should be disclosed more widely to the interested persons or referred to in open court.
Thank you. And I think there's a very important point there where we're talking about managing expectations around disclosure, and in both inquests and inquiries, material that is disclosed to the chair or to the coroner does not necessarily get onwardly disclosed. So in inquests, we look at the Lewis funnel and ensuring that the coroner has all of the information he or she needs. That's not to say that all of that will be disclosed to interested persons. And similarly, in inquiries, not all of the information that is provided will then be onwardly disclosed to court participants and then indeed made public. So I think there is a piece there to be said around managing the process and the understanding around what actually happens with disclosure when you're at the very first stage of the process and disclosing it just to the chair or the coroner. So I thought that is an interesting point to also pick up on.
For a court participant, Charlotte, I mean, certainly my experience is that the best way to manage it is to have a dialogue with the inquiry. If you're able to make it clear to the inquiry why there's particular sensitivity, which may not be obvious from the documents that they're being sent, it's much more likely that the inquiry will deal with that sensitively, particularly given the subject matter of a number of the inquiries that are dealt with. So again, it's back to communication and what I said earlier on, really. It needs to be communicated both ways between the inquiry and those who are involved, and from those involved back to the inquiry, to try to achieve what is ultimately a fair approach to dealing with information, some of which is, as Shona's mentioned in the context of inquests, very sensitive. Health records, things to do with people's mental health that may have an effect on them if it's then referred to again in public, and ultimately dealing with people who've passed away, and that does call for sensitivity on both sides, an understanding of the need on occasion for information to be revealed, and equally a recognition that some information can be protected without ultimately harming the overall investigation that needs to be carried out.
Absolutely. And I think that comes back to the overarching point here, which is that one size doesn't fit all. And it is important to give clear reasons which are specific to the information in question, and having that dialogue, but ensuring that it is not a blanket approach which is being proposed. So it is very clear why that information should be protected.
I think in terms of inquests, it can be challenging for organisations, and to echo exactly what Paul has said in terms of inquiries, the most effective approach in the context of inquests is early and transparent engagement with the coroner's office. And if redactions are proposed, the organisation should clearly explain what has been redacted and why, allowing the coroner to determine whether the balance between privacy, relevance and open justice has been properly struck. And redactions also help ensure compliance with data protection law, where information relates to living individuals while still preserving the transparency of the inquest. I just wanted to mention here some recent case law, because Charlotte, you raised a really important point. In the recent case of relatively recent 2024, our IAB and others versus the Secretary of State for the Home Department and Secretary of State for Levelling Up Housing and Communities 2024, the Court of Appeal held that in judicial review proceedings, the names of junior civil servants cannot be redacted as a matter of routine. I think that was the point you were picking up on, Charlotte, and indeed Paul earlier. And that case made clear that junior civil servants cannot be redacted as a matter of routine without good and specific reasons. And redactions may be justified in exceptional cases, for example, for national security or where there is evidence of a real risk to the personal safety of the individual concerned. But indeed, routine redaction is not acceptable as a matter of course. And similarly, although again, I stress not in the context of inquest, but interesting nonetheless, last year the Supreme Court, in the case of Abbasi and Hastrup, highlighted that the treatment of patients in public hospitals is a matter of legitimate public interest, and that medical and other staff of hospitals are public figures for the purposes of the convention analysis, meaning that the limits of acceptable criticism are wider than for private individuals. However, the court also made clear that anonymity or other restrictions are not automatic and must be justified on the facts, and shown to be proportionate.
Thank you, Shona. Both important cases in the context of giving reasons and ensuring that they are specific to the circumstances. And I think we see that where inquiries publish their redaction and anonymity protocols, which commonly refer to the need for specific reasons to be given, notwithstanding the fact that it may be that they are junior members of staff. It needs to be a specific reason relevant to that member of staff. So I think that does also come across in the protocols that are published by some of the most recent public inquiries.
I think there's one other area, Charlotte, that I would have in mind when we're talking about all of this, and that's about the need for good record keeping. And it might sound slightly dull, but for the lawyers amongst us, we always have to have regard to what the risks are. And if we're making decisions, if it's the inquiry or if you're dealing with staff members and their data, on either side, it's important that a good record is kept about how decisions have been arrived at and what were the bases advanced and accepted for allowing a particular redaction or other step to be taken when it comes to their information. The reason why that is also important is ultimately if there were to be a challenge to the decision that's made. And I think, as lawyers, it's our job to make sure that those who are making those decisions, so an inquiry chair, or if it's an employer who happens to be a core participant in an inquiry, that they are able to demonstrate that they haven't just made a decision off the cuff without any thought, but instead of properly engaged with the questions that they have to in order to decide the correct approach in that particular instance.
Yes, I definitely think that is worth mentioning. The importance of ensuring that there's a clear audit trail in respect of any decisions that are being made. Do you have any other closing remarks in respect of the topic and challenges that we're navigating in data, in inquiries and inquests?
Well, I should just say I indicated I'd give some top tips, and I should come back to them, Charlotte. So I will if that's all right.
Absolutely.
So in terms of inquests, first, and I appreciate this may sound like an obvious one, but to understand the legal framework, data protection law applies only to living individuals, as we've stressed, not the deceased. And an inquest is a statutory process, so coroners have the power to require disclosure of relevant material. The second tip is to think carefully about redactions. If you're concerned about disclosure, it is usually better to seek clarification from the coroner's office as to whether the material is actually needed for the purposes of the inquest, rather than applying a blanket approach to redactions. And over-redactions can create unnecessary difficulties. The coroner has a duty, as we've discussed earlier, to balance the interests of privacy, confidentiality, and open justice. And thirdly, early engagement with the coroner's office is key, as we've also touched on. If a request feels too wide or raises confidentiality concerns, I think it's important to raise that early, ask questions and seek directions if needed. And in my experience, disclosure issues are much easier to manage if they are addressed early on, rather than left to the last minute, although I fully appreciate that last minute instructions are sometimes unavoidable. So those would be my 3 top tips.
In terms of any closing remarks from me, I think what I would say is that data protection risks sounding like quite a dull topic, but actually in the context of public inquiries and inquests, it's really central to a lot of the work that has to be undertaken. Because of the nature of and the volume of information that's received, having a good understanding about the responsibilities that we all have to deal with it appropriately is a core aspect of ensuring a successful inquiry where the people involved buy into the process, recognise the need on occasion for information to be shared so as to ensure an effective investigation into the matters that are being considered. And so whilst on one level perhaps seen as a dull topic, it really is something very important for those that are involved to get their head wrapped around before they engage.
Absolutely. Thank you both. There's lots of great tips there for our listeners, and thank you very much for joining me today to discuss this important topic.
It's been a pleasure. Thanks for having us.
Thanks very much, Charlotte.
Thank you for listening to Evershed Sutherland's Through the Inquisitor's Lens podcast.